And I don't know, I don't think he would be eligible because he has 2 drunk driving charges. Ms. Moore?
We're filing on his first, Your Honor. As the Attorney General's response, I did speak with Mr. Byrd, and he informed me that he successfully completed the alcohol abuse classes as well as community service. The classes helped inform him of the dangers of drunk driving and how badly it affects others. Also, having to deal with the struggle of not having a driver's license helped Mr. Byrd understand what a privilege it is to be able to operate a motor vehicle. He has no
Right here's the setup. A man with multiple drunk driving convictions is asking the judge to erase one from his record. But with such a history, could redemption outweigh repetition? Stay tuned.
In St. Paul Church, and he's seeking expungement in hopes that this will help him get his license back. As far as his Michigan State Police report, he's had no other convictions since 2019.
Haven't already, and let's go ahead and roll the game film.
All right. Aaron Byrd?
Yes, Your Honor.
Ms. Moore, are you there?
Good afternoon, Your Honor. Yes, I'm here.
All right. Let's see here. 0565 710, People versus Aaron Byrd.
Good afternoon, Your Honor. Shanice Moore, P83784, on behalf of Mr. Byrd.
Right. Counsel, I have a motion to set aside. It's an operating while visibly impaired charge. I don't see that I have a letter back from the Attorney General's office. And I don't think he would be eligible because he has 2 drunk driving charges. Ms. Moore?
We're filing on his first, Your Honor. Only the first OWI is eligible under Michigan law. And I can email over, or we can fax over the AG's letter. I have one dated January 6, 2025.
Well, if you could read that to me, I would be grateful.
Sure.
Start with that.
People v. Aaron Byrd, Oakland County District 44, docket number D359825. Dear Clerk, given the information currently in possession of the Attorney General, review of Byrd's application and criminal history report shows he may be eligible to have his conviction set aside under MCL 780.621. Byrd's 2005 conviction of operating a motor vehicle while impaired may be eligible for a set aside as a first violation of an operating while intoxicated offense. Per MCL 780.621C4, the court may consider whether or not the petitioner has benefited from rehabilitative or educational programs, if any were ordered, or whether such steps were taken before sentencing for that first violation. The court is not constrained by the record made at sentencing and may deny the petition if the court is not convinced that the petitioner either used such programming or benefited from it after completion. After this court holds a hearing, and if it agrees Aaron Byrd meets the statute's eligibility requirements, it may enter an order granting the application only after this court also determines that Aaron Byrd's post-conviction circumstances and behavior warrant setting aside the conviction and that it is consistent with the public welfare to grant Aaron Byrd this privilege. Very truly yours, Michael Ajami, Assistant Attorney General.
All right. Thank you, counsel. If we would like to make some arguments, go ahead.
Yes. So as far as the Attorney General's response,
Notice how the defense leans on community service, church attendance, and business success. But the prosecution reminds us, eligibility is one thing, worthiness is another. Do you think past growth should erase repeated mistakes?
I did speak with Mr. Bird, and he informed me that he successfully completed the alcohol abuse classes as well as community service. The classes helped inform him of the dangers of drunk driving and how badly it affects others. Also, having to deal with the struggle of not having a driver's license helped Mr. Bird understand what a privilege it is to be able to operate a motor vehicle. He has no pending criminal charges. He's owned his own real estate company for about 8 years. He has 3 children. He volunteers with the sports teams at his children's schools, and he also attends St. Paul Church. And he's seeking expungement in hopes that this will help him get his license back. As far as his Michigan State Police report, he's had no other convictions since 2019.
So he had this offense in 2005. It is difficult for the court to come to the conclusion that he embraced or really benefited from any of the programming that the court offered at that time, because the next year he picked up another drinking and driving offense. And then in 2009, make sure that I'm accurate. Accuracy is important. In 2009, there was a third drunk driving and the Third Circuit Court in Detroit. And then in 2018, there was another drunk driving in Mount Clemens. Counsel, I can't in good conscience agree that it would serve the public welfare or that the post-conviction circumstances justify setting aside this conviction. It's unfortunate that he, at least in this court's, from this court's vantage point, is not entitled to or hasn't conducted himself since 2005 in a manner that is deserving of this consideration. But it is what it is. There's no sugarcoating his record after 2005, especially when it comes to drinking and driving. So the motion is denied.
Okay, thank you, Your Honor.
So the judge denied the motion, stressing public safety over second chances. It's a tough call. Fairness or forgiveness? What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.
Thank you.